Hello, I am Aditya Gupta and I am a lawyer at the Delhi High Court. Today we will be studying the module of copyright infringement. By the end of this module, I hope you will understand the different rights available to an owner of a copyright, the tests for infringement of copyright, as well as how each of these rights are available for the different kinds of works. Let's begin. First, a bit of a recap. As you have studied in earlier modules, there are different kinds of works which are protected by copyright. The relevant section here is section 13 of the Copyright Act, which provides that copyright shall be available to literary works, dramatic works, musical works, artistic works, sound recordings, and cinematograph films. Therefore, it is important to note that each of these works are entitled to different kinds of rights, and these are the rights that we will study today. First, let's move on to the meaning of copyright. For the meaning of copyright, you need to study section 14 of the Copyright Act. Section 14 defines copyright and says that copyright is the exclusive right to do or the exclusive right to authorize someone else to do several acts. Copyright essentially is a bundle of exclusive rights, and in a broad sense they can be categorized as follows. First, the right of reproduction. Second, the right to issue copies. Third, the right to public performance and communication. Fourth, the right of adaptation and translation or modification. And lastly, the right of sale or rental. We will study each of these rights, some in more detail, and some, as you can see, are pretty self-evident, and thus we will not go into as much detail for some of these rights. First, let's see the right of reproduction. This is the exclusive right to make a copy of a copyrighted work. As you could probably imagine, this is the heart of copyright law, the right to copy the work. In order to prove that the right of reproduction has been infringed, the plaintiff must prove two things. First, the defendant copied the plaintiff's work as opposed to creating it independently, and two, that is, there is substantial similarity between the plaintiff's works and the defendant's work. Let's see the first requirement first. The first requirement is that the defendant must have copied the plaintiff's work, and thus it must be a case of copying as opposed to independent creation. Independent creation is a complete defense in copyright law. Independent creation means that the defendant or the alleged infringer came up with the allegedly infringing work without having any reference to the plaintiff's work, or even without knowing of the plaintiff's work. There are several ways through which a plaintiff can try and prove that the defendant has copied the plaintiff's work as opposed to creating it independently. One way is a very direct way, which is about mechanical copying. For instance, if the defendant makes copies of the CDs containing the plaintiff's work, then clearly it is a case of copying as opposed to independent creation. But not all cases are so simple. There may be cases where it is difficult to know whether the defendant has actually copied it or created the work independently. There is sometimes direct evidences of copying. Sometimes the defendant might even admit that it copied the plaintiff's work and solely limit its defense to the second prong of the infringement test, that is, the defendant's work is not substantially similar to the plaintiff's work. An interesting case in which the defendant admitted to have copied the plaintiff's work was Roger versus Coons in the United States, wherein the defendant admitted that it had seen the plaintiff's work and then had instructed his artisans to copy it. His defense in that case solely related to substantial similarity and the doctrine of fair use, which you have studied in another module. Let's move back to the ways in which a plaintiff can prove that the defendant has copied his work. One, as I mentioned, is the direct evidence of copying. The more common way of proving that the defendant has copied the plaintiff's work is by combining two different tests. First, the plaintiff must show the defendant had access to the plaintiff's work, and apart from the access, the plaintiff needs to also show that there is probative similarity between the plaintiff's work and the defendant's work. By showing access to the plaintiff's work, the plaintiff shows that an inference can be made that the defendant must have copied the plaintiff's work. Thus, the plaintiff needs to show that the defendant either had direct access, or by virtue of the fact that the plaintiff's work was so widely disseminated, it can be presumed that the defendant has access to the work. For instance, the plaintiff may have handed the work directly to the defendant. This is clearly a case of access. Or it might be a case where the plaintiff's books or movies were widely published and were available in many bookstores or movie stores. In this case, it can be presumed that the defendant had access to the plaintiff's work. But access by itself is not enough to prove copying. The plaintiff must also show that there is probative evidence of similarity between the two works. The plaintiff must show that the similarity is such that the court can reach an inference that the defendant copied the plaintiff's work. It is also important to note that the higher the degree of similarity, the more likely it is that the court will infer access. That is, in cases where the plaintiff is finding it difficult to prove that the defendant had access to the plaintiff's work, if the plaintiff can show that the defendant's work was very similar to the plaintiff's work, then in that case the court might even infer that the only logical conclusion is that the defendant must have had access to the plaintiff's work and has copied it. A very important way on which certain plaintiffs rely to prove access and copying is that the defendant has even copied the errors in the plaintiff's work. For instance, the plaintiff has made some grammatical mistakes in his work, and the defendant copies even these grammatical mistakes, then it is quite clear that the defendant must have copied it and did not apply his own mind and did not create the work independently. The second part of the test relating to infringement of copyright is improper appropriation. That is, the part of the plaintiff's work that the defendant copied must amount to improper appropriation. What does this mean? That is, if the defendant copied certain unprotected elements of the plaintiff's work, it does not amount to copyright infringement. As you can imagine, almost every copyrighted work has some protectable elements and some unprotectable elements. The examples of unprotectable elements are ideas. In an earlier module, we have studied the idea-expression dichotomy, which says that only the expression in a copyrighted work is protectable but not the underlying idea. Let's say the defendant copies the idea of the plaintiff's work but not its expression. Can it be said that the defendant has infringed the plaintiff's work? The clear answer is no. For the copying to reach the level of improper appropriation, only the protected elements of the plaintiff's work will be considered and the unprotected elements will not be considered. Similarly, there are certain scenes which are considered as savoir faire. For instance, there are certain elements which are stock of the trade, and every person, every creator of any work is entitled to use them, and even if the defendant has copied such savoir faire from the plaintiff's work, it cannot be considered to be copyright infringement. A landmark case relating to the tests of infringement of copyright is R.G. Anand versus Deluxe Films. This is a case from the Supreme Court which lays down the test of substantial similarity, and it is worth reading the case and I highly recommend it. It is important for us to go over the test as called out by the Supreme Court, and I will deal with each one by one. Firstly, where the same idea is being developed in a different manner, it is manifest that the source being common, similarities are bound to occur. In such a case, the court should determine whether or not the similarities are on the fundamental or the substantial aspects of the mode of expression adopted in the copyrighted work. What the Supreme Court is really trying to say that when people are copying from a common source, it is bound to happen that they will copy the same ideas. What the courts have to really look at is whether the defendant has copied the plaintiff's expression. This is clearly an extension of the idea-expression dichotomy, wherein only the expression of a copyrighted work is protected but not the underlying idea. Secondly, if the defendant's work is nothing but a literal imitation of the copyrighted work with some variations here and there, it would amount to a violation of copyright. In other words, in order to be actionable, the copy must be substantial and a material one, which at once leads to the conclusion that defendant is guilty of an act of piracy. What this means is that the defendant cannot get away by making small variation in the plaintiff's work. But it is also important to know that the copying must be substantial and material. We will discuss the de minimis test subsequently, which is relevant for this point. Thirdly, and this is very important, the Supreme Court says that one of the surest and the safest tests to determine whether or not there has been a violation of copyright is to see if the reader, spectator or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original. Therefore, it seems that the Supreme Court wants a viewer or a spectator to see both the works and then from his point of view whether he would consider them to be copies of each other. Some courts have said that this looks like a common man test or a look and feel test, whether the look and feel of both the works to a common man appears to be the same. Let's go to the next point. However, apart from the similarities appearing in the two works, there are also material and broad dissimilarities which negative the intention to copy the original, and the coincidences appearing in the two works are clearly incidental. No infringement of copyright comes into existence. It is important to read both these parts of this sentence conjunctively. The court says that there must be material and broad dissimilarity between the two works, which would negative any intention to copy the work, and secondly, any similarities must only be incidental. Therefore, if the defendant adds a lot of material to the plaintiff's work and there are material and broad dissimilarities between the two works, it may be considered not to be copyright infringement if the second condition is also satisfied, that is, the coincidences in the two works or the similarities in the two works must only be incidental. Lastly, the Supreme Court held that the violation of copyright amounts to an act of piracy. It must be proved by clear and cogent evidence. Therefore, the court said that the standard of proof to prove copyright infringement seems to be a high one. Let's understand the ratio laid down by the Supreme Court by means of a case study. The case study that I'll be dealing with today relates to a movie called Dhoom 3. Dhoom 3 was a movie produced by Yashraj Films, and after the release of the movie, an allegation was made by a script writer that the movie was copied from the plaintiff's script. Let me give you a few background facts about this case. After the release of the movie, the plaintiff claimed to have seen Let me give you a few background facts about this case. After the release of the movie Dhoom 3, the plaintiff claimed to have gone and seen this movie and then found out that the movie seemed to have copied the script that the plaintiff had allegedly submitted to the defendant's studio way back in the year 2010. He then alleged that even though he had not heard from the defendant's production house for the past 3 years, it was quite clear that they had the plaintiff's script in mind while they were making this movie. The defendant also seemed to have copied substantial parts of the plaintiff's script. This was the case of the plaintiff. The Bombay High Court took up this case and decided on the motion of grant of an interim injunction against the release of the defendant's movies through television channels. The court found two things. Firstly, that the defendants did not have access to the plaintiff's work. The court reached this conclusion on the basis that the plaintiff's story regarding access was too far-fetched. Several things went against the plaintiff here. The court first found that the plaintiff did not include sufficient details regarding his visit to the defendant's offices when he filed the plaint, and it seemed to the court that his story was an afterthought. Secondly, the court also found that there was no substantial similarity between the plaintiff's work and the defendant's work. Here, the court relied on the R.G. Anand versus Deluxe Films case. What the court found that the similar parts between the plaintiff's work and the defendant's work were only ideas or sense-faire. Let me give you some examples. The defendant movie also pertained to certain magical shows which were conducted and was a story of two brothers and a story of revenge. The court found that each of these were only ideas or sense-faire, and even though both the plaintiff's work and the defendant's work had some similarities, these similarities could be traced back to other pre-existing works relating to magicians, involved twin brothers, and were stories of revenge. The court found that even though these similarities existed, they could be traced back to pre-existing movies or pre-existing works, and by now they can be considered to be sense-faire, allowing anyone, including the defendant, to use these while making its movie. The court therefore came down hard on the plaintiff and said that the plaintiff did not make out any case of copyright infringement at all. Therefore, through this case study, I hope you understand that the bar of proving copyright infringement seems to be a high one, wherein the plaintiff must establish that actually the expression of the plaintiff's work has been copied by the defendant, even though the underlying idea of the plaintiff's work might have been copied by the defendant. It would not amount to copyright infringement. Now let's move on to the doctrine of de minimis infringement. I mentioned in the context of the R.G. Anand versus Deluxe Films case that the defendant must have copied a material and substantial part of the plaintiff's work. In another case, the Delhi High Court applied this and said that the doctrine of de minimis infringement also applies to copyright, where the copying by the defendant was de minimis, then the acts of the defendant will not be considered to be copyright infringement. The court found 5 different tests which apply with respect to de minimis infringement. Firstly, the size and type of the harm, the cost of adjudication, the purpose of the violated legal obligation, the effect of the legal right on the parties, and the intent of the wrongdoer. Where the size and the type of the harm caused to the plaintiff is minimal, the court usually finds that this is not worth being considered copyright infringement and is too trivial for the court to look into. The other factors such as cost of adjudication, purpose of violated legal obligation, effect of the legal right on parties, and the intent of the wrongdoer are less relevant as compared to the first factor. This was all about the right to reproduce. Let's look at some of the other rights contained in section 14 of the Act. The second right that I'd like to deal with is the right to public performance and communication. The term communication to the public means making any work available for being seen or heard or otherwise enjoyed by the public directly or by any means of display or diffusion other than by issuing copies of such work, regardless of whether any member of the public actually sees, hears, or otherwise enjoys the work so made available. What does this mean? This means that an owner of a copyright has the exclusive right to communicate or perform the work in public. A very simple example would be that a person cannot show a cinematograph film in a movie theater without first taking the permission of the owner of the cinematograph film and paying appropriate royalty fees. Therefore, this is a very important right for the owner of a copyright, wherein he is able to prevent the dissemination of his work to the public without enjoying certain economic benefits from that dissemination. In the terms of a literary work, the performance of the work by recitation, for instance, would also be prevented by a copyright owner unless he gives permission for the same. If a recitation is done without his permission, it would infringe his right of public performance of the work. The next set of rights available under section 14 is the right of adaptation, translation, and modification. The owner of a copyright not only has the right with respect to the work he creates, but also has the right to prevent others from making an adaptation of his work. Therefore, he has the right to prepare what we call derivative works. As the term suggests, this means the works which are derived from the original work. For instance, any alteration made to the work. Take for instance an abridgment of a book. An abridged version of a book is considered to be a derivative work, and therefore to prepare such an abridged version, the person preparing it must take the permission of the owner of the copyright in that literary work. Secondly, for instance, the author of a book has the exclusive right to adapt the book into a movie. You might be aware of the Harry Potter series of books. As you now know, most of these books have been converted into movies, and each time a person makes a movie out of these books, then in that case he has to go back to the author of the book, that is J.K. Rowling, and seek her permission to make a movie out of the book. Similarly, others have also relied on the underlying characters of the book and have come up with their own versions of different stories pertaining to those characters. Again, those books which rely on the same character as the Harry Potter books are considered as adaptations of the original books, and again, permission must be taken from the owner of the copyright in those books for preparing such adaptations. For a broader definition of what adaptation means, you can have a look at Section 2 Clause A of the Copyright Act, where the term adaptation is specifically defined. Once you read it, you will understand that the term is defined quite broadly. The next set of rights is the right to issue copies. It is the right under the Copyright Act is a right to issue copies of the work to the public which are copies not already in circulation. Therefore, if the plaintiff puts a work into the public and it is already in circulation, he does not necessarily have the right to prevent further dissemination of that particular copy. However, he has the right to prevent others from issuing fresh copies of the work. This is the right to issue copies under Section 14, and he cannot control the copies which are already in circulation. The next right available under Section 14 is the right of sale or rental of copies of the work. This right is relevant for computer programs, cinematograph films and sound recordings. For instance, in respect of a computer program, a person is debarred from renting the CDs containing such computer programs, and this amounts to an infringement of copyright. Similarly, you may be aware of movie rental stores. Each of these movie rental stores must take permission from the owner of copyright before they can rent out a movie to the public. This is to ensure that the economic right available to the owner of copyright is not completely diminished by virtue of such practices such as hiring or renting out of such CDs containing computer programs or cinematograph films or sound recordings. These are the set of rights which are available to the owner of a copyright. Let's just go over them quickly once more. That is the right to reproduce, the right to issue copies, the right to publicly perform and communicate the work, the right to modify, adapt or translate the work, and the right of sale or rental of the work. Under Section 14 of the Act, different kinds of rights are available for different kinds of work. For instance, literary, dramatic, artistic and musical works enjoy very wide rights under the Act. As opposed to this, cinematograph films and sound recordings enjoy fewer rights under the Act. Computer programs, in fact, enjoy very broad rights. They enjoy all the rights available to literary works as well as the right of sale and rental. At the end of the module, you will see a chart which I have prepared to show which rights are available for which kinds of work. Now let's summarize our learnings of today. We first studied the different kinds of works which are entitled to a copyright under Section 13. We then studied the meaning of copyright and the different bundles of rights available under Section 14 of the Act. We studied the right to reproduce, the right to issue copies, the right to publicly perform and communicate the work, the right of adaptation and translation, and the right of sale or rental. As regards the right to reproduce, we found there are two specific requirements: that the defendant must have copied the plaintiff's work and that there must be substantial similarity between the plaintiff's work and the defendant's work. The most common way of proving copying is by showing access to the plaintiff's work as well as a copying of the plaintiff's work by the defendant by showing similarity between the two works. As I mentioned, the level of copying must rise to the level of improper appropriation, such that the copying of unprotected elements cannot be taken into account while considering whether the defendant has copied the plaintiff's work. Unprotected elements includes ideas and savoir-faire, and in this regard, the R.G. Anand versus Deluxe Film case was discussed. Just to recapitulate, the test for copyright infringement is that if the reader, spectator or the viewer, having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original, it is considered copyright infringement. To understand this test, we looked at the Dhoom 3 case study and found that the bar for proving copyright infringement appears to be a rather high one, since quite often courts find that what the defendant has taken is only the idea or the savoir-faire from the plaintiff's work. We then studied the test of de minimis infringement, and then we moved on to the right of public performance, right of adaptation, and the right to issue copies. And then we found that different kinds of rights are available for different kinds of work. Thank you.